In what comes as a landmark judgment, the Supreme Court today upheld the state's power to grant separate quotas for more backward groups within the scheduled caste and scheduled tribe categories. Now, the apex court, in a 6-1 majority, has overturned a previous ruling that ruled subclassification as anti-constitutional. However, the court has also had words of caution for states. Ashmit joins us now to take us through the details. Ashmit, take us through why the court decided to overturn the previous order, but more importantly, the guardrails that the court also hopes to put in place.
Well, indeed, another landmark verdict coming in from a bench headed by the Chief Justice of India. This, of course, was 7 judges. The decision in favour of granting states that power of granting that quota within a quota. It was a 6-1 majority. That's effectively the main takeaway here. That Supreme Court, what it has done is that it has allowed states to introduce a quota for certain specific backward minorities within the SC/ST quota. Now, all of this issue arose when the state of Punjab had sought to do this way back in 1975. Since then, there have been various rounds of litigation. Now, what's important as of right now is that the Supreme Court held that the SC/ST community is not a homogeneous entity. That it's a heterogeneous community. There are differences. There are some communities that do better than others in terms of socioeconomic standards, that do better than others in terms of representation at the government level. And that is something that the Apex Court has taken note of and said that the state governments will be fully within their remit, will be fully competent to pass laws, to pass legislation that provide additional affirmative action, additional quotas and reservation within that SC/ST quota. Now, that is not without the sense of guardrails. The Supreme Court has said that, number one, any decisions by the state governments cannot be based on whims and fancies. It cannot be based on political expediency. It has to be based on empirical data regarding backwardness and regarding possible opportunities that are being sought to be created. Not just that, the Supreme Court has also said that any such decision, any such legislation passed by a state government will be subject to judicial review. That means it can be challenged in a court of law. So essentially, the long and short is Supreme Court saying states can introduce a quota within a quota, but there are guardrails as well, and it will be subject to judicial review.
All right, Ashmit, many thanks for joining us. It is day 6 of the Olympics.